Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Today we're discussing a subject dear to my heart, partly because I spent years working to reduce the number of children detained in custody pre-trial. We call it remand. Rob and I are joined by two people immersed in the subject. Angus Jones is the lead inspector of prisons for children, and Mel Stooks is a youth defence lawyer for GT Stewart. Rob, nearly half the children in prison are on remand. Does that surprise you?
Well, you use the word prison. That's not quite right, because children under 18 can be locked up in a variety of places. Yes, prisons, but also secure accommodation of various kinds. But yes, it really surprises me. It was only a quarter of children behind bars were on remand 10 years ago. Now it's almost half. It's a higher proportion than the adults in the criminal justice system.
Which seems weird, doesn't it?
It does, because, according to the law and policy, we should be doing absolutely everything to keep that age group out of custody, but something's not working.
Angus, the inspectorate, which you work for, has just published a report looking at children remanded for 7 days or less. Why look at this in particular?
Well, I think it's the most flagrant example of the problems in the system. In the last year before we conducted this fieldwork, we saw that about 200 children were remanded to custody only to be let out a few days or weeks later. And of those, about 60 were held for just 7 days or fewer. And I think what we are looking for here is opportunities to improve the conditions in which children are held. Those 200, many of whom might not need to be there and will be released in short order, put pressure on the rest of the estate and degrade outcomes for all of the children that are held in custody. But there's also another point, which is I don't think anyone thinks it's sensible to remand someone to custody for 7 days.
But surely 7 days or less doesn't do any real harm to that child.
Well, I think you get all of the harm and none of the benefit. You are disrupted from your home or your social care placement. You are taken into custody where you will likely witness violence. You will certainly witness abusive language and threatening behaviour. And then you will undertake several meaningless assessments because they will never provide any service to you, because you will be disrupted only a few days later when you go back out into the community, maybe to a completely different placement. So in the space of 2 weeks, you've had your life turned upside down twice. Anything useful you were doing in the community has been disrupted, and we're setting you up again with less resources than you started off with.
I can understand it might be a bit of a waste of time, but in terms of the actual harm, what kind of things might a child be subject to which could actually harm them?
Well, we had a child who was involved in our sample. They came into custody. They were there for a handful of days, and during that time, they watched someone being stabbed through the window. That's quite harmful. And that's an extreme example. But during your first few days in custody, children will shout abuse at you out of the window. They will try and find out where you're from. And the general volatility of these institutions you will be subject to. So you might not experience being assaulted yourself. You might not experience being a victim of bullying, but you will almost certainly observe that happening. The other thing about where you'll be held during your first few days in custody is during your induction, you're not going to education, you're not doing anything productive. So what that means is you will be locked in your cell. Now, in most YOIs, the average child is locked in their cell for more than 19 or 20 hours a day, every day, more at the weekend. But for these children, during their first 7 days, they're locked up for even longer because there's nothing else happening. All they're doing is coming out their cell, being assessed, put back in, and then a few days later, they're being released.
I mean, Mel, you represent children and I guess do your very best to keep them out of custody, but where they do go, does that sort of experience that Angus has talked about, does that ring true?
Absolutely. And I think what you have to bear in mind is that their arrival is not going to be their first night in custody. They will generally have arrived at court from a police cell, having spent at least 1 or 2 nights in the police station. They will already have suffered the particular harm that's been researched for being held overnight in a police station. And they then arrive at a young offenders institution where, as Angus has very eloquently put it, very little happens to them and it has completely harmed them without any benefit.
Harmed in what way, though, Mel?
A lot of the harm is psychological. It is often the first time that some of the children have been removed from their family setting, if not a stable care setting. Many of the children in the criminal justice system have vulnerabilities and neurodivergences that require routine or an idea of what to expect. And sometimes the sensory overload for them can be absolutely overwhelming.
I mean, Angus, these children who are on remand, shouldn't they officially be held separately from people who are sentenced, either in separate institutions or separate parts of institutions? They haven't been convicted after all. Shouldn't they get a better deal in custody if they have to go there?
I think in an ideal world, all the children would get a better deal with custody. I think when we're talking about depriving children of their liberty, sentenced or not, we should be putting them in institutions that meet their needs. Now, whether we separate remand children from convicted children is a separate discussion, but my view is that to do so would overcomplicate an already complicated landscape in our justice system. We have half a secondary school's worth of children in the justice system and 4 separate types of institution for no good reason to hold them. To generate yet another assessment centre for remand children, I think would make things worse, not better.
And Mel, we're talking about children between the age of 12 and 18 who are actually pleading not guilty to the crime that they're accused of. What justification is used to imprison children who are, after all, innocent until proven guilty?
So I think the reason why children are remanded probably fall into 2 broad categories. There are children who are already in the care system, who are accused of very low-level offences, either against police officers or against the care setting, and the placement decides not to have them back and a new placement has to be found.
A new place for the child to live.
Yes, and so with children's services being stretched and perhaps with the child in question having numerous vulnerabilities or perceived difficulties, placement finding can be difficult. The other core of children who are refused bail at courts are ones who are before the court for a serious offence, and because of the seriousness of the offence, the court feels that it is too much of a risk to release them on bail.
So do you mean like murder, rape, robbery?
Murder would fall into its entirely own category, as there is no presumption of bail for a child charged with murder. The majority of cases in the youth court where bail would be refused for a serious offence would be knife-point robberies, sexual offences, and there are quite a large number of grievous bodily harm. So that's the more serious end of the scale of assaults.
And just to say, in our work, we looked in detail at 25 children subject to these 7 days or fewer remand episodes. And nearly all of them were accused of violence against a person offences. We very rarely see accusations of low-level offences coming into children's custody. We're seeing quite serious offences that do need some thinking about in terms of risk management in the community.
The data analysis Transform Justice has done has actually revealed that 1/4 of all children on remand have been accused of non-violent offences. And I have to say we include possession of a knife with that, but not any use of the knife. So I agree the majority is violent offences, serious offences, but there are still, amazingly, a lot of non-violent offences as well.
Well, as I say, in our sample, we have about 80% are accused of violence. The rest are not. So similar to your figures, I think trying to work out the offence profile is, I think, less fruitful than trying to work out why they didn't have another alternative at court, because actually we see some very serious offences being released into the community with supervision and some less serious offences being remanded into custody. And what we would want to see is that work happening that got those children the appropriate support and supervision in the community happening for all of the children, not just those that are lucky enough to live in the areas where they put that together more quickly.
So what were the actual legal justifications that judges and magistrates made for remanding these children? Because I thought either they had to, worry that they weren't going to turn up, worry that they were going to interfere with witnesses, or commit another offence. Those are the three basic things. Is it the last of those, that they're worried that the young person's going to go out and do a similar thing again?
Yeah, well, broadly speaking, that's the issue. In all of the summaries that we've seen some allusion to risk and the difficulties of managing that in the community. But in nearly as many, we've also seen issues of vulnerability. In one case, we saw a child remanded into custody where their vulnerability was given almost as much weight, and the lack of being able to manage that vulnerability in the community as the risk and the offence that they were committing. They had been in and out of healthcare settings, and the judge was concerned that they needed somewhere safe to be. Many of these children are both very risky and very vulnerable all at the same time.
I mean, Mel, when you're representing somebody, what are the sort of circumstances where you think, crikey, I'm going to have a real fight on to keep this young man, I guess we are talking about mainly young men here, out of custody?
Well, I'm actually going to talk about the girls first, because it's them that generally are charged with offences within the care home or against police officers because there have been welfare concerns, or they are not happy with their placement and trying to get another one. And it is those cases where the courts are most likely to say, well, it's for their own welfare that we are remanding them into custody, because unfortunately, whilst the whole of the youth justice system is supposed to be focusing on welfare as a way of keeping children out of custody, it is also a legitimate reason to send them into custody. But equally, I have relatively recently had a case where a lad who had no previous criminal record was charged with attempted murder. He was exceptionally vulnerable, and I did not really expect my bail application to work. In all of the circumstances, I was making the bail application based on the fact that at the end of the case, I did not think a custodial sentence was inevitable. Fortunately, we were in front of a very sensible district judge that was amenable to that argument, and it's only because I think she's so senior that was a persuasive argument. I would not expect that to work in any other court.
Just in terms of the process, when you're standing up in court arguing that this child shouldn't go into prison, he should be on bail, is there a prosecutor or a police officer saying to the district judge, no, I'm sorry, it's so serious, he's got to go? Is it an adversarial argument that's played out or not?
It's an incredibly adversarial argument. On a really bad day, you'll have both the prosecutor and the investigating officer there saying the same things. But the prosecutor will generally, where there is a serious offence, be saying that they should not be given bail.
And you mentioned, I think, that if a child has been arrested and has been in the police cells overnight or whatever, comes up in court the next morning, does that increase the chances that they're going to end up being remanded in custody for a further period, or doesn't it make any difference?
I personally worry that it must be psychologically easier to remand a child in custody who has arrived in police custody. If a child has been refused bail at a police station, a custody sergeant has already scrutinised the decision as to whether or not to let that child out. So there is the idea that somebody has already looked at the investigation, the circumstances of that child, and made a decision to keep them in custody. Sometimes, however, you can use the awful experience of being in a police station overnight as an argument against sending them into further custody for longer.
Angus, the children you were looking at, They all got released on bail for the rest of the period before they were actually tried. What changed when they returned to court?
So there's a couple of things. I think you probably need to be careful with the language. They didn't all get bailed, but they were all released into the community.
Oh, yeah, because there's another form of remand, isn't there? It gets a bit complicated.
Yeah, they're generally in the community with some conditions, and there'll be some accommodation. I think what changes in most of these cases was a coherent plan. Because if there isn't a sensible plan, you've got someone accused of something quite risky, you're going to end up remanding them to custody. What typically happened between the first court appearance where they were remanded and the court appearance when they were released was that there was a plan involving accommodation, supervision, and something to do. In every case, it was possible to manage their risk in the community. What we need to do is make sure, rather than waiting, we do it on day one. We get that together more quickly. And in order to do that, we need to work out a way for those local youth justice services, which are based in little council areas, to interact better with the national court system. And we think that that's best done by working in regions rather than individual local areas, particularly when they're dealing with children that are few and far between.
But how realistic is that, Angus? If you've got a child who's arrested, charged with a very serious offence, in court the next morning, there simply isn't the time for the youth justice worker, the lawyer, the local authority, the care system to find a suitable... It takes a bit of time to set up, doesn't it? Isn't that what that 7 days is effectively being used for?
Well, it is in some cases, yeah, but I don't see any real problem apart from a lack of organisation, perhaps a small lack of resources in certain parts of the justice system, but not all of it. If local areas had more experience of these children, could communicate better with the courts about what the court expected in terms of what plan they would accept for bailing or releasing into the community, and because they were in larger areas, had a bit more resource to actually do that more quickly, I think we could start chipping away at this issue. And I use the term chipping away intentionally. This is not an issue with one big solution. This is an issue of coordination and communication.
Haven't they tried something like this in Manchester, I was reading about, where they try and get the local authorities to work together so that they can provide a quicker response to these kinds of cases? Is that a model?
That is a model, yes. And there is some focus there on some accommodation as well. I don't think accommodation is a big issue for these children. Many will get accommodation. It's about timeliness of that accommodation to resolve the remand in the first place. But in Manchester, what you have is a dedicated resource focused on reducing the number of children that are remanded from that area. And I think that's a start. And for some boroughs in Manchester, it's transformative because before they were so ill-experienced in dealing with remands that they wouldn't get enough resource to do the job properly. So if you're only remanding 0 or 1 child a year, you're playing with very little money. You need to coordinate with the City of Manchester to get the resource over the wider area.
So, Mel, we've heard that accommodation or placements, as they're called, is a big issue. Can we just drill down? What is the court concerned about in terms of the child staying in their own home? I mean, I can understand a children's home saying, we won't keep the child, but there are also presumably lots of children where that's not the case, and still the court says, we want you to live somewhere else if we're going to consider bail at all. What is it that they're worried about?
So I think it's a concern about the wider community. The children might be at risk of violence in their own area. They might be at risk of exploitation in their own area. County lines, as everyone sees it, is no longer cities sending drugs to the countryside. Exploitation and county lines happens on children's own doorsteps these days. And it is the fear that causes that makes adults not want them to be placed in their own area. We recently had a client who was granted bail, but the bail was supposed to be granted with an exclusion from his home borough.
So he was supposed to not either live or go into his own home borough in London.
Yes, he was accused of a serious assault on someone. So they were concerned that there would be retaliation for that. They were also concerned that the people who had encouraged him to commit that offence, allegedly, might be encouraging him to commit other offences. The family were not able to find an alternative address for him. Children's Services said they couldn't help. And it took a number of hearings for the court to eventually agree that he should go and live with another family member in a different area of the country. But that had to be risk assessed because they had to check that there were no issues with the adults caring for him there, or that he would be safe there.
So you think the courts are generally right in their risk aversion about children staying where they live on bail?
No, I don't agree with their risk-averse attitude at all. I think that where a bail support package is properly provided by the Youth Justice Service, then they are the people who are best placed to assess risk.
I mean, Angus, in your study, did you find lack of a suitable place to stay was one of the big reasons that children and young people ended up being remanded to custody?
So in many cases, it was more about assessing that place to stay or getting it approved. The two areas where I would say we saw most issues were around accommodation. The second was about supervision. And in one or two cases, we saw children being remanded for very short periods of time. And the only difference between the first hearing and the second hearing in terms of supervision or accommodation was a couple of extra check-ins a week. Now, I see no reason why they had to wait for that.
So you're saying that you've got a child and a proposal of bail was put forward on day 1, and say on day 7, the next one was put forward. And the only difference between these two was that the child would need to check in with their youth justice worker 2 more times than in the first proposal.
Yes,
that was it.
That was all that changed. There was 5 check-ins on the one that was rejected. There were 7 check-ins on the one that was accepted. Again, this doesn't seem to me a good enough reason for a child to be in prison for this period of time.
Where there was a need for some new placement or place to stay, I mean, what kinds of places are we talking about here? I mean, Mel mentioned one where somebody goes to another family member to stay. I mean, that's presumably one. But is the stuff that local authority children's services should be providing, foster care or children's homes? What are the options?
So exactly as you described, we have sort of family placements, sort of kinship placements, so extended family. There are foster placements, but they are very few and far between. The accommodation could also be a sort of semi-independent or independent living arrangement, which is essentially a flat or bedsit with support around it. And that would be people coming in to try and meet the needs of that child, both supervising their risk and trying to get the child to go to something that was likely to benefit them, education and so forth. It's perfectly reasonable that takes some time, but for lots of these children, these placements are the same. And so we need to get to a point where youth justice services have a suite of options that is likely to work, is communicated with the court ahead of time, and is then more likely to be accepted.
We did a survey of practitioners, Transform Justice, and I think the message we got from youth justice practitioners was that one of the challenges they have is that they know the kind of placement that's needed, but children's services who've actually got to provide that placement don't understand the urgency of the ask.
And I'm absolutely sure that there's truth in that. These sort of bureaucratic issues are all solvable, and I think a bit more focus on this group, some resource to coordinate the response and working in larger areas should be able to deal with these blockages in the system. I would wager that most of that feedback comes from places that don't do it often. If children's services are not used to dealing with children that are coming up to court and are at risk of being remanded, they are less likely to get on the bus and do it quickly.
Mel, I mean, you've heard from Angus that, you know, there is sometimes not a huge difference in the bail package that's produced when the child is released, having been remanded. Is that your reality, that you're in the court on that first appearance and it can be a struggle to get the kind of proposal together that you think will reassure the court? Because you can't do it. You have to be dependent on youth justice services and children's services. Is that your reality?
Yes, particularly when the child is out of area.
What does that mean?
If they are in a court which is not local to where they live, then the Youth Justice Service, who is either reliant on someone back in the home area putting the information together, or in fact, if they can't get hold of that person, they are trying to provide their own, then it's not going to be as robust as perhaps the court needs. And sometimes it is literally the home borough putting the package together, very similar, in fact, to the Youth Justice Service package that has been at the court. But because it has come from the home borough and they are able to flesh it out a bit more with a bit more information about the child, then it can look sturdier than it did at the first hearing.
What do you do if the Youth Justice Service simply says, we haven't got enough information, we're not going to propose that we could supervise them on bail? Do you still argue as a lawyer for that child to be on bail, even if you haven't got the Youth Justice Service on your side?
Yes, I have numerous examples of when Youth Justice Services have told me they will not support a bail application, and I have still gone ahead and argued it anyway, because there are occasions where you can provide enough conditions to allay fears of risk at the first hearing, and then the Youth Justice Service, for example, can come back at the next hearing and say, well, as you have considered them suitable for bail, we will now suggest adapting those conditions to this.
But it makes your life presumably much, much more difficult if the Youth Justice Service themselves say, we haven't got anything together at this point.
So much harder, yes.
Yeah. Another sort of surprising thing about children who are remanded in custody is quite how many are black or brown. A far greater proportion of the children who are on remand are black or brown or from other minoritized communities, even than children who are sentenced to custody. So why are so many children who are black and brown remanded?
I think we have to talk about the very uncomfortable subject of adultification that does exist in the youth justice system. And that means that certain children can look older than their chronological age. They could be bigger physically, or they could look facially more mature. A 15-year-old who is over 6 foot and a little chunkier than a smaller white 15-year-old boy is going to be treated different in the courts. That's really what adultification can be.
But is that subconsciously, you're saying? It's not a judge or magistrate saying, blimey, you look big and tall, and therefore I'm going to remand you to custody?
I'm not an expert on adultification, but I would suggest it is a subconscious bias.
Angus, what about you? Have you got any views on this disproportionality issue and as far as remand's concerned?
I think it's long existed, and it reflects a difference in the success of diversion over the last 10 years. So in my career in the youth justice system, I've seen disproportionality get worse. Now, all groups are diverted more than they have ever been. But as we've got more successful with white children, we haven't been as successful with black or Asian or mixed heritage children. And that has led us to this problem. Now, HMIP doesn't deal with why people are there. We deal with the conditions and the services they get. And I also think there is a danger within the justice system that we place at the justice system's door all ills of society. Now, there's an absolute reason why children from inner cities who have had difficult lives, who have health conditions, and may be more likely to be black, Asian or mixed heritage are being remanded and convicted at a higher rate to their white counterparts. But dealing with what the justice system can do without support from other services in the community, I think it's a very difficult question to address.
2/3 of children who are remanded actually don't go on to get a custodial sentence. What do you think about that?
It's indefensible. There is no way that we should be remanding this amount of children into custody when many of them have no prospect of getting a custodial sentence. What we see at the minute is a system where remand is used at a very different rate to the adult system, more than twice the adult system in terms of population. And we see that nearly 2/3, around 6 in 10, don't get custody when they come to court, and many of them are acquitted. So I think there needs to be some real thought put into making those figures sound a bit more reasonable.
I mean, you both seem pretty convinced and convincing that many children who are remanded to custody don't need to be. It's unnecessary. But do you each think that there are some children in some circumstances who do definitely need to be detained as they wait for their trial? Mel?
I would say very, very few. And I think part of the problem I have with that situation is that the places that they are going to be detained awaiting their trial are not conducive to their welfare or suitable places for them to wait. There are always going to be a small handful of children that may require more secure accommodation than others, but I don't think what we are offering is the right place for them to wait.
And how about you, Angus? Do you think there are some that really, come what may, will end up being remanded in custody?
Yeah, absolutely. There are plenty of children that come into custody who are accused of very serious offences and go on to get very long sentences. And when the test is met, we as an organisation fully support that. So long as they're not waiting for years for that trial, there's a legitimate chance that they're going to get a lengthy custodial sentence. I think that that's what remand is for. What I think we can do is move on to thinking about how we reduce the numbers of these other children who get out anyway and use the extra space that gives us in the estate to improve those institutions where we're putting these children.
Okay, thanks. That's been a fascinating conversation, but sadly we have to draw it to a close. We finish by asking each of our guests if they were Lord Chancellor, maybe you will be one day, what one thing would you do, in this case, to reduce the number of children remanded in custody? Mel?
If it was only one thing, I would change the law so that a court could not remand a child on the basis of their own welfare.
Okay, thanks. Angus?
I think I would focus the resources where they're needed most. We need to focus not on a national solution, one that deals with where the bulk of these children are coming from. And we're talking about London and the other metropolitan areas and maybe some of those counties around them. And I think that looking at those regions more effectively would help in terms of dealing with this issue.
Okay. Penelope, how about you? Your Transform Justice is doing a lot of work on this issue.
We are doing work on the issue, trying to advocate for a reduction in unnecessary child remand. And I think this podcast illustrates that there's quite a lot of unnecessary child remand. I think I'd look at the police and the prosecution and try and educate them. I know that sounds a bit patronising, in the realities of what child remand is, because no child is ever remanded without the prosecution proposing that basically they should be remanded. And I'm not convinced that the CPS really understands the harm that is done by it. Rob?
Well, I wonder about some more guidance for the courts who are making these decisions. I mean, it's interesting. We have the Sentencing Council that makes guidance on guidelines on sentencing, which are pretty binding, and they've been very good for children and partly have led to the numbers coming down. But there's no guidelines on remand decisions, and I think both for adults and for children, that's a big gap that needs filling.
I agree, actually. Thanks to Angus, Rob and Mel. And if you'd like more detail about Transform Justice's work on remand, or to read the Inspectorate's report, or to look at the work of Mel Stooks, do look at our programme notes. Goodbye.
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 Goodbye.